All right, in this video, we're going to go over the 7 stages of a trial, okay? And I've made these up myself. It's not something you're necessarily going to see in a trial advocacy book, but generally speaking, this is how I break down a trial. The trial will begin with what's called as voir dire. It's a fancy term. It just means this is jury selection. And we can get into the mechanics of jury selection in another video, but as a general rule, each side is going to be given an opportunity to ask questions of potential jurors to see if they have any biases that would make them unfair to serve on this particular jury. For example, some people have moral reasonings, good held moral beliefs, can never impose the death penalty. They may be a great juror on a drug case, maybe a great juror on a second-degree murder case, but they can't sit on the first-degree case because they, no matter what, will never be able to consider death as a possible penalty. Now, how do people get excluded from jury? Well, the law says that there's an unlimited amount of challenges for cause. So in that case, if someone can't follow the law as given by the judge can automatically exclude them. Secondly, each side will get a number of what's called peremptory challenges. It's basically, gut feeling cuts, okay? You can cut someone for whatever reason. If they've got too many family members that are police officers, they really were not paying attention to the questions I was asking, or, they've kind of indicated to me that they may require me to do certain things in my defense that I'm just not going to do. And so those could be reasons to exclude somebody. The law makes it clear you can exclude someone for any reason, so long as it's not based on race or gender. You can't say, I don't want this person on my jury because they're white and I'm representing a black person. You can't say, I don't want this person on the jury because, pick your prejudice. They're white and I don't want, or my defendant's black and I don't want a white person on the jury. Whatever it is. It just can't be based on gender or race, okay? And if it is, there's a whole procedure where you can get people excluded for gender or race back onto the jury panel. Additionally, each side will have a number of cuts. The number of cuts for those peremptory challenges will be dependent upon the size of the jury needed for the case. Under Louisiana law, each party is going to get the same amount of cuts, and it's going to be equal to 1 cut per juror. So it's a 12-person juror, each side gets 12. If it's a 6-person juror, each side gets 6. So in multiple defendant cases, let's say you have 2 defendants, each defendant will get either 6 or 12, and then the state will get 12 or 24, just times it by 2. The second stage of a trial is what's called the opening statement. The opening statement is where the lawyers get up and tell the jury what they believe the evidence will show in the case, and then based on what they believe the evidence would show in the case, what they believe a proper verdict should be. Now, the law requires the state to do an opening statement, okay? And so they are supposed to get up there, say what their case is about, and the types of evidence that they will be presenting. An argument can be made that evidence not reasonably foreseeable to that opening statement can be excluded from being presented at trial. That's more of a historical argument, as modern discovery practices have basically tried to eliminate a trial by ambush. Now, the defendant can put on an opening statement, does not have to do so. As a practical matter, every trial that I've ever done, every trial that I've ever seen as a prosecutor or defense attorney, the defense did put on an opening statement. Once opening statements are over with, because the state has the burden of proof, they go first and they present what's called their case in chief. This is where they call all of their witnesses to establish the facts necessary to prove each and every element of the crime beyond a reasonable doubt. What they'll do is they'll put on a witness, then the defense attorney will come up and ask some questions. That question is called cross-examination. During the cross-examination, they'll be trying to attack the veracity of the witness, meaning they can't be believed, either about who they are as a person or how their testimony is inconsistent with other testimony, how their testimony is inconsistent with the physical evidence, or just inconsistent in general, okay? After the defense attorney does that, the state will then do what's called a redirect examination, where they try to assess the highlights of the defendant's cross-examination to get the witness to explain more about why what the defense attorney is talking about does not attack the testimony they are having to offer. Now, after the state rests their case in chief, it is the defendant has to decide if they want to put on a case. Remember, the defendant does not have to put on any evidence at all. They can rest on their presumption of innocence, and the judge will instruct the jury not to have any adverse finding of that fact. Now, if should a juror require the defendant to put on any evidence, including the defendant's testimony, that person theoretically should never have been on the jury. They should have been excused for cause because they cannot follow the law. But let's assume the defense puts on the case. The defense now can call whatever witnesses it wants to show why the defendant's not guilty. Sometimes these witnesses would be to establish what's called an alibi. All an alibi is someone saying, hey, look, I didn't commit this crime because it took place on this day and this time, and I was over here on that day and that time, and here's my witnesses to show you that. So it's not me, you got the wrong person. Other times, witnesses are offered to attack the testimony of other witnesses. An example of that, well, you heard Johnny say A, B, and C. Well, you should know, from me, the defense witness, that Johnny once told me D, E, and F. Okay, so you're attacking the consistency of Johnny's testimony there. The biggest consideration is whether or not the defendant's going to testify. A defendant has the absolute right to testify. He also has the absolute right not to testify. That's his decision alone. It's not the judge's decision, not his lawyer's decision. And if he chooses not to testify, even if they put on a case, the judge will instruct the jury not to hold that against the defendant. And if someone were, again, they should have been excused for cause. Now, assuming the defense put on a case, the state, because they have the burden of proof, they get to go first and they get to go last. They can then put on additional witnesses to rebut the defendant's case. These are other witnesses to challenge the testimony of the defendant's case. It's not redoing our case in chief. It's limited to what was presented by the defense. Then any other witness called or testimony engaged that's outside the scope of the defendant's case could be excluded as not being relevant. Now, once the defense and state's rebuttal case is over, the case goes to closing argument. This is where the attorneys get up and they remind the juror of the highlights that they saw in this trial and why that supports the particular verdict they're asking them to find. Again, the state gets to go first and last, and the defense attorney does their argument in the middle. Once arguments are done, the judge will instruct the jury on the law. They will go back and they will render a verdict. And so those are the 7 stages of trial. It's really 5 to 7 stages, just kind of depending on whether or not the defendant testifies. Any questions, you can email me, call me, I'll have links below. In Louisiana, there are 4 different ways that you can post bond. What a bond is, it's a surrendering of some type of property or assurance that would allow someone to be released from jail and go to court while their case is pending. The easiest way to make a bond is by posting a cash bond. Someone is arrested, the judge looks at the seriousness of the charge, looks at their criminal history, and then says, I'm going to set a bond in the amount of $10,000. Well, if the person or someone on their behalf wants to pay that, they can take $10,000, go deposit it with the sheriff, and then the person will be released. So long as the person comes to court, when the case is over, regardless of the outcome of the case, the person or his family will get the $10,000 back. Now, if they do not appear in court, then they will forfeit the $10,000. The second type of way to get someone out of jail is with a property bond. And so this is where someone pledges home or land as collateral for the bond. Now, the property has to be located in Louisiana because the court has to have jurisdiction over the land. And you can stack up multiple pieces of property to satisfy the bond, but this is how it works. You look at what you pay in property taxes, you look at your assessed value. You take from that assessed value, you subtract any liens. Generally, that's a mortgage or a second mortgage. And then that difference is what is available to post a bond. Again, you can stack up multiple pieces of property if you need to. It only costs a couple of $100 to file a lien in the court record and a couple $100 to remove it. So it's pretty cheap, and as long as you think the person is going to show up for court, you really don't have anything to worry about. The third type, and it's probably the most desired, is a sign-out bond. This is a release on your own recognizance or a release from a personal surety, someone who says, I will make sure they go to court. This is basically the honor system. As long as the person goes to court, no one really has to pay any money. other than like a $30 or $40 processing fee with the sheriff's office. But if someone doesn't show up to court, then whoever is the surety, whether it's the defendant himself or his mom or his dad or his wife, will then be personally obligated for the entire bail amount, and then can have liens placed on their property, wages garnished, what have you. That is not reserved for every type of bond. It's generally for nonviolent crimes or misdemeanors, and generally reserved for first offenders. Now, the most common bond is the commercial bond. That is where you go and actually pay a bail bondsman to post a bond for you. What you do, the state law of Louisiana says you have to pay 12% to a commercial bail bondsman. They can't charge 14%, they can't charge 10%. It's 12%. 2% goes to the bail bondsman. The other 10% goes to execute an insurance contract with the sheriff that posts your bond. You, as long as you appear in court, you don't owe any other money. If you do not appear, then the court can move against the bail bond company's insurance underwriters for the full bond amount, and you have signed over documents that allow the bail bonds company to go after you to indemnify them for the loss in its entirety. Now, the downside is that when the case is over, you don't get any of your money back. But it is the most common way to get people out of jail, because people do get arrested for serious crimes or are repeat offenders, and they tend not to have property or cash to satisfy large bond amounts. So the bail bondsman can work. Those are the 4 ways to post bond in Louisiana. Bail bondsmen work 24/7. Property bonds are done during normal court hours. Personal recognizance or cash bond can be done any time of the day.